Hey, everybody, this is Kevin Sutton from the Education Practice Group at Miller Johnson. Thank you for joining us for our 5-minute message. This is our first substantive series of our 5-minute message. And today's topic is going to be the new U.S. Supreme Court decision in Kennedy versus the Bremerton School District. It involves Joseph Kennedy, who was a high school football coach who often prayed on the 50-yard line at the conclusion of football games. Initially, when he was doing this, they were private prayers. Eventually, however, he started being joined by other folks, members of his football team, members from the other football team, and spectators would join him at the 50-yard line for this prayer. The school district, somewhat naturally, became aware of what was going on, and they were concerned about this. They asked the coach to stop because they believed the prayers were being held on the football field by virtue of his employment. He was a football coach for the football team and was doing this right at the end of the game. So they suspected that he was still on duty, and they were concerned that a reasonable observer would conclude that the school district was endorsing his religious beliefs and endorsing this activity. Logically, the school district officials believe that if people thought the school was endorsing this activity, that might blur the lines between the separation of church and state. They tried to talk to the coach on a few different occasions about this activity. He refused to comply with the school district's request to stop. School district, as a result, gave him a poor performance evaluation and did not renew his coaching contract. Again, in a 6-3 majority opinion drafted by Justice Gorsuch, the court stated that teachers and students should not be required to shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. The Supreme Court used that phrasing of shedding rights at the schoolhouse gate way back in the 1960s in a student speech case called Tinker versus Des Moines that had to do with students wearing black armbands in the school in protest of the Vietnam War. The court held that because the coach's prayers were private and not within the scope of his employment, they were protected by both the First Amendment free exercise clause and the free speech clause. Importantly, the majority tells us in the opinion here, a government entity sought to punish an individual for enjoying a brief, quiet, personal religious observance duly protected by the free exercise and free speech clauses of the First Amendment. Now, that's a little bit of a constitutional mouthful, but in essence, what the court is saying here is that the school district overreacted. The school district believed that it had a duty to ferret out and suppress this observance in furtherance of the separation of church and state. But the court is saying that the school district went too far. They didn't have to do that. Not surprisingly, there was a strong dissent filed by 3 justices. Justice Sotomayor indicated that the court, in their majority opinion, had elevated an individual's interest in personal religious exercise in the exact time and place of that individual's choosing over society's interest in protecting the separation between church and state, thus eroding the protections for religious liberty for all. And you've recognized this individual's right to pray, but what about the separation of church and state? Wasn't the school kind of onto something when they were trying to keep that separated? They were particularly concerned that the majority had not recognized a very long line of precedents that the court had ruled on to keep church and state separated, particularly in public schools, because the court has previously recognized students as being particularly vulnerable and deserving of protection. I think very importantly, it does appear that the majority's ruling is limited to this idea of a private, quiet prayer that is not coercive to students. There's some debate as the case comes out about, well, you're saying it wasn't coercive, but was it? You know, if I'm a member of the football team and I see my coach and a bunch of assistant coaches and a bunch of maybe the upperclassmen kneeling with my coach on the 50-yard line, do I really feel comfortable just waltzing into the locker room? Or maybe should I stick around and take a knee just to make sure that coach doesn't look upon me disfavorably or anything like that? And so there's been a lot of debate about that as the decision has come out. Ultimately, I think as we move forward into this school year, we know that this is going to be a protected right. And I do think we're going to see some pushes from staff members about the limits in terms of what they can do and not do. I think very importantly, though, is that idea brief, quiet, and private. And so the idea that a teacher could be, leading a class in a prayer, I don't think that works under this Kennedy decision. The right of the teacher, perhaps at a time where maybe it's student passing time, or they don't have students immediately in front of them, to take a moment of private reflection and say a prayer themselves. I think that's something that absolutely is going to be protected under this decision. Just a reminder that we've got 5-minute message videos coming out here very frequently, certainly during the school year, but in particular here over the next couple weeks. With that, we sign off on this edition of the 5-minute message. Thanks so much. Take care.